How does Illinois treat postnuptial agreements in a high-asset divorce? A postnuptial agreement can protect everything you have built together, but in Illinois, one legal misstep can render it completely unenforceable. Unlike prenuptial agreements governed by the Illinois Uniform Premarital Agreement Act, postnuptial agreements fall under general contract law and the Illinois Marriage and Dissolution of Marriage Act 750 ILCS 5. This distinction matters enormously because postnuptial agreements require valid consideration and exchange of value to be legally binding, a requirement that prenuptial agreements do not share. A postnuptial agreement is simply a written contract signed after marriage that defines how property, debts, and spousal support will be divided if the couple ever divorces. For Illinois courts to enforce one, both spouses must sign voluntarily, without coercion, and with a complete, accurate accounting of every asset, debt, and income source. Agreements presented during a marital crisis or immediately before a major financial transaction carry a significantly higher risk of being challenged and voided by a judge. The terms of the contract must also be fair and not unconscionable at the time of signing, and having separate legal counsel for each spouse dramatically reduces the risk of a later challenge. In high-asset divorces, Illinois courts apply heightened scrutiny to financial disclosures, particularly when the marital estate includes closely held businesses, investment portfolios, or complex trusts. Judges carefully verify that both spouses fully understood the rights they were waiving, and vague or understated business valuations are a frequent trigger for legal challenges. A valid agreement cannot shield hidden wealth. Any undisclosed or omitted property will be divided by the court under standard Illinois equitable distribution rules, regardless of what the contract says. Courts also scrutinize the circumstances surrounding the signing itself, as illustrated by the 2024 appellate decision in re Marriage of Chamberlain, where a postnuptial agreement was voided after one spouse signed while medically incapacitated. The court ruled that agreement both procedurally and substantively unconscionable, a reminder that even a well-drafted contract can fail if the signing conditions are compromised. At Caesar & Bender, LLP, co-founding partner Michael Ian Bender is a former domestic relations judge for the Circuit Court of Cook County, bringing rare bench-level insight into how Illinois courts evaluate and enforce marital contracts. Co-founding partner Molly E. Caesar is a certified mediator recognized by Super Lawyers for Family Law, who has litigated marital agreement disputes at the trial, appellate, and Illinois Supreme Court levels. The law firm's attorney team handles high-asset marital division matters involving business valuations, trusts, and investment portfolios across Chicago and Cook County. If you are considering a postnuptial agreement or facing a high-asset divorce, call Caesar & Bender, LLP at 312-236-1500, located at 150 North Michigan Avenue, #2130, Chicago, Illinois 60601, United States, to schedule your consultation today.